Ghosh from Syracuse University, talking to us today about contract law and business law and competition law interface. Professor is a widely prolific author with publications across the spectrum, and we hope that you will have a good time with this talk.
Yeah, thank you. Thank you for the invitation. It's very nice to visit here at the Philadelphia campus. I've heard so many good things, and it's good to actually be here. And I'm very excited to discuss my work with you. My background is in both law and in economics. So I teach primarily in the law school. I taught primarily in law school, but I've often had very close contacts with the business school. So prior to being at Syracuse, I was at Wisconsin for 8 years, where I had a special position. I was in the law school, but I worked closely in the entrepreneurship program. That was centered in the business school, but had affiliation with the law school, engineering school, and agricultural economics. And so, in fact, during that opportunity when I was at Wisconsin, I had a chance to meet your colleague, Professor Basant, who was visiting in Wisconsin for a year, I think 2010, 2011, something like that. So I'm very happy to be here, so thank you. I know on a Friday afternoon it's always difficult and it's the absolutely depressing things, but in fact, thank you for taking your time to meet with me. I'm going to talk about technology licensing. And technology licensing, as Professor Pingala mentioned, involves issues of contract, involves issues of intellectual property, and we'll talk a little bit about the interaction between those two as they arise, for example, in business law as well as in competition law. And so the starting point for my talk is an observation that many researchers have noted that many companies, many entities such as universities may have a good patent portfolio or an IP portfolio more broadly, but as far as disseminating the technology, that tends to be a lot weaker. And so what's the explanation for that? Is that explanation based upon law? Is the explanation based upon something within the management structure, within the organization? If there's some market failure happening? And so when we start thinking of those terms, then the natural question is, are there things that could be done to reform or make the situation better? And so there have been many suggestions about trying to facilitate the commercialization and dissemination of technology. And so one idea is to say that there should be a special type of patent, that the current patent system only rewards or only benefits those who've invented something. But it doesn't necessarily give you any direct subsidy or direct encouragement for commercialization, other than private self-interest. And as I'll discuss in a few minutes, there are many reasons why just simply having the property right doesn't mean that you'll necessarily transfer the property right. And so there are lots of standard explanations that I'll get into regarding this issue. And so some people have suggested using another type of patent, sometimes referred to as a commercialization patent or an innovation patent. There's just lots of different names. And there are different types of schemes, and they're very interesting. I'm more skeptical about those schemes, thank you, about using even more property rights when current sets of property rights don't seem to be functioning. But the basic idea is to give some encouragement to those who not only invent but also commercialize. And yeah, sure, please.
Yeah, the dissemination just means only commercialization?
Yeah, good question. No, I'm using the word interchangeably now, maybe too easily, but it can be dissemination through many means. And I'll talk a little bit, for example, of open source, right? So I think that may be one of the aspects that you're thinking about, or some sort of donation or something. But I'm talking generally when I say a transfer, that it's a problem. We don't even see open source, right, happening at least at the level that we might find desirable. The basic problem, as I'm stating it, that people have observed is maybe we're very good at creating things, but not as good at disseminating them, either through commercial means or other things. And certainly the idea behind the commercialization patent is based upon dissemination through commercialization. They're not very good, those proposals, in my opinion, between open source or encouraging open source or other things other than pure market-based. And so that's worth thinking about. Other suggestions that have arisen involve something like some sort of a commercialization award or subsidy. So the state or the federal government, whatever the entity might be, can give some direct subsidy, maybe through
capital, ignite funds, if you're familiar with other types of things, to promote the development of businesses or dissemination. Again, those proposals don't talk as much about it, but you can imagine structuring those proposals so that there might be some encouragement for open source if that's what is desirable. Okay? So there are some proposals, and I'll talk about other aspects that might be there. I'm fairly skeptical about either the property rights or just purely a direct subsidy type approach. I think a lot of the problems arise from some market failures or structural failures in licensing, and there may be some ways in which that can be resolved through other means, such as, for example, competition law, or through how we think about patents themselves in terms of the structure of that property right. So let's discuss a little bit about why there's an issue. And so when we're trying to measure these types of things, many of the issues are based upon anecdotal evidence as well as some survey evidence, some issues, for example, regarding the phenomenon of non-practicing entities in the US and also in the European Union. So entities that simply acquire patents for the purposes of financial investment or maybe for litigation purposes. There seems to be some sort of concern or view that patents are largely there for litigation value. And so many companies might be obtaining patents, not necessarily to commercialize the technology, but one maybe offensively. So they're seeking to have some sort of position in litigation. And if there is any type of licensing, the licensing is really a mechanism for settling litigation rather than actually disseminating the technology. There might be some side effect of disseminating the technology from the licensing, but the primary motivation is the offensive use in litigation for patents. And of course, there's also the defensive use of patents that arise, that if I'm sued, if somebody basically brings a patent infringement lawsuit against me, then I can use any patent portfolio position I have either to defeat somebody else's patent or to maybe enter into some sort of cross-licensing. So the point of this is that maybe the dominant paradigm or model, at least in the business sense, is one of litigation rather than dissemination. And that seems to be the practice when you look at some of the debates over non-practicing entity. Yes, please.
What type of market failures you are talking about?
Yeah, I'm getting to that a little bit. Certainly, one of the market failures that I'm describing now might just simply be one of perception. That people, and there's sort of a circularity there, that companies or entities that pursue patents are doing it in an environment of litigation, where it's largely fighting over the property rights. So the type of market failure that's sometimes described there is, sometimes they refer to it as a notice externality, but it may be some informational failure, because the reason why there is litigation, some people argue, some of it may just be brought offensively, maybe through the use of dominance, maybe in an anti-competitive way, which raises some antitrust, so there's strategic litigation. Some of it also may be the result of the fact that the patent itself is not clear what's covered. And so a lot of the litigation arises because there's not clear boundaries. For example, with software patents, it might not be completely clear. And so somebody who has obtained the patent might then say, well, because there's this lack of clarity, I can exploit it. And so that view is, that can take many views. One is that's a strategic type behavior by firms in obtaining patents. The other view is maybe, once the patent was obtained, there was some goal for commercialization, but because the patent is not having clear boundaries, then there's this preliminary, protracted, maybe non-ending litigation just simply to define the property right that then makes it very difficult to actually contract or transact with the property.
Can we argue that probably the patent holder does not know the fullest extent of what use the patent entails, essentially?
Yes, and partly might be the use, so that might be another corollary by not knowing what the patent entails. So, this is very interesting from a psychological standpoint or looking at the strategic standpoint. There is some notion within the firm or within the company that they have to obtain patents, but it may not be completely clear why. So there might be some theory behind patents as being defining property rights for the purposes of contracting, but the reality is very different. So part of that might be a question of making it clear why you obtain patents. And the other thing may be that within the patent system, you can have the patents more clearly delineated, right? And so you have reforms sort of going in both directions.
Because if your idea of using it for settlements and legal disputes
Yeah.
would have a boundary condition essentially. You know, the value
Yeah.
of the settlement cannot be more than the commercial value of the patent.
Maybe. I mean, that's interesting.
Right. I mean, so unless of course there's an uncertainty about the
Right.
value that the patent will bring to the table essentially.
Right.
And you may be a better marketer than I am.
Right.
And therefore, in that space only can one define patent as being used for legal purposes.
Yeah, there's an interesting. I think that's right. I don't know if the commercial value serves as some sort of, as you said, people may not know what it is, and there may be some concern about what the market is. I mean, so let me give you an example. One of the dominant theories of patent law is the prospect theory associated with Edmund Kitch. And the prospect theory, his argument in the 1970s was that you obtain patents in order to have some sort of a claim that you can then use to develop and identify markets. In his theory, there is some uncertainty as to what that market might be. It might be fairly large, it might be fairly small, but the point is you have that claim. The problem with the prospect theory is that if the claim itself is not clear or uncertain, so that you simply have taken some sort of a stake, but you're not completely clear about what that stake is, it's as if you're buying a lottery ticket, right? The payoff might be great, the payoff might be small. We often think about buying lottery tickets as being irrational in some sense, but in this particular case, if you have enough lottery tickets, and if there is some litigation value as maybe at least the floor for what the value of your patent is, then you're still willing to invest in that type of activity, which is very different than the commercialization.
The other argument one could think of is in the university system.
Yeah, good.
Started out.
Yeah, and I was going to go to that as an example, so this is the question.
Nonetheless, I mean, so it's
It's a perfect time question.
it could be looked upon as akin to publication requirement.
Yeah.
The fact that you have one is a signal in value and that's where it stops.
Right.
Whether or not it's commercialized is not a problem of the professor.
Yeah. Right. So the university setting is interesting. I mean, and I think you suggested some of the issues that arises in a university. Why get patenting? So, in the U.S. context, and you see this issue coming up in other jurisdictions. You have the Bayh-Dole Act in 1980. And if you go back to the idea behind the Bayh-Dole Act, the idea behind the Bayh-Dole Act, I think in India the variation that was proposed was the public utilization of publicly funded research. I forget the exact name of the act that was proposed a few years ago, but it was never enacted. But it was basically a version or really an expansion of the Bayh-Dole Act. So the idea is that the Bayh-Dole Act was enacted in 1980, and before 1980, if a university or other entity received government funding for research, and that research resulted in something that was patentable, then the university could not take a patent position. They were largely restricted by whatever the terms of the grant would be from the government, and the grant typically did not allow for patenting. The view was that the public has already paid for the invention through taxes, and they don't need to pay it again through licensing fee. But the argument that came up is that this prevented many of the technologies from being disseminated, right? And so this is an argument even before Bayh-Dole Act, and the whole idea behind the Bayh-Dole Act then was to create these property rights, allow patenting so that they could commercialize. And so this is 1980, 36 years later we're having the same debate, right? So instead of having technologies that are then, or inventions that are somehow locked in the university, now we have patents that are locked in the university. So again, that suggests that something other than property rights were the problem about why there might not be commercialization with universities. And as Vishy suggested, one of the reasons for that might be what exactly is the perceived value of the patent. In other words, the incentive structure within universities is not to necessarily create startups, even though you have many very famous examples of startups, Hewlett-Packard being maybe one of the more famous examples from going back to the 1950s. That's not necessarily the way in which the universities, you have promotion, you get advancement, and so forth. You have lots of other types of rewards, and commercialization of business is not one of them. Okay, and so there's that aspect. And so patents then serve as the equivalent, maybe as you say, maybe it's like publication. you get those types of internal rewards, and you don't have the time or the wherewithal to. And that might also be true in non-university settings. So there's a lot of argument for why, at least startup companies get patents, even though there might be some debate about the cost-benefit of a patent. But there is some evidence to suggest that venture capitalists like to see a patent portfolio. And they may not have any, again, they may not have an idea. In fact, they may have less idea than the science people, than the research and development people, because largely they're business, they're finance people. And so they don't understand the technology. They don't understand maybe the underlying legal rights. But they can see the patents, and that signals to them, as you suggested, something about how serious the business is. Maybe there's a notion that once the government grants a patent, the government is somehow giving some sort of endorsement or certification for the novelty and non-obviousness of the patent. It's like any sort of signaling theory. It could mean lots of different things, and that's what they're looking for, but not the ultimate commercialization aspect of this. So the university setting is quite interesting when you think about this for illustrating the signaling point, but it can also arise in non-university settings, where it's simply obtaining the patent becomes a goal in and of itself, rather than understanding what may be one of the theories or one of the purposes of obtaining the patent. Okay, and so everything I've said so far, one of the arguments could be made is, well, okay, but that's really the purpose of the patent system. The patent system is to encourage invention, and if people are inventing things, does it really matter? That's a separate issue as to whether they're going to the market. That, you can look at it in lots of different ways. Society is better off by having the invention. Then it's just simply a distributional question about who gets it. And that distributional question could be resolved in lots of different ways, but that's separate from the goals of the patent system. So if the patent system is about, whether it's operating through signals, whether people don't understand what the nature of the patent system is and it's getting embroiled in litigation, putting aside the costs of litigation, at least you do have invention. Okay, and so maybe the patent system is basically working, even though there might be these side problems. And so I think a lot of the view, though, is that that can't be enough, just simply having the invention, right? Just simply acquiring an asset without necessarily getting some of the usufruct or the benefit from that asset, can't be necessarily beneficial to society. You think maybe analogies, for example, to land holding. But you can't just simply say because one person has acquired a huge parcel of land but has done nothing with it, that somehow society is better off. Well, that might be true, maybe not true. If you have fallow land that was never used and now we put a boundary on it and give it property rights, maybe in some sense society is better off. We can make that argument. But if you're losing the benefits from the commercialization, then there's an argument to say that there might be some degree of waste of that particular resource, so that actually individuals are worse off, at least not necessarily better off than having to find the property right. So I think you have to think about the commercialization aspect of this, and I've sort of given you some examples of why there might be some sort of a failure in the marketplace or in the dissemination aspect of this particular commercialization venture. And then we can also get into a little bit in some of the behavioral economics or other psychological literature that obtaining a patent or obtaining any type of property right sometimes makes the holder of that property right value it more than maybe what it should be valued. So this is the idea behind the endowment effect, that if you give somebody, it's usually done with experiments involving small tokens or coffee mugs. If you have a coffee mug and you say, how much are you willing to spend for this? They might give you a willingness to pay a certain amount. Then if you give them the coffee mug and ask them, how much do I have to pay you to relinquish it? They'll give some higher amount. Again, this is an interesting, there's a lot of discussion about what this might mean. At some level, you might be willing to you generally want to make a profit, so what you're willing to accept may be very different than what you're willing to pay. But the point behind the endowment effect is that under the Ghosh theorem, if you have the property rights defined, then individuals would just simply negotiate. If transactions costs are zero, then it doesn't really matter who gets the property right, because it will just simply go to whoever it values it most. But the point behind the endowment effect is that who values it most will depend upon who has the property rights. At least that's the counter argument. And so it's not quite clear that even in a world of zero transactions cost, that necessarily the property right will go to who values it more because it's endogenous at that point. Right, so we can take that apart. I mean, there's lots of criticisms of the endowment effect, and it's very interesting. But in the context of patent law, it has maybe some interesting application that I might be willing to pay so much in research and development to obtain the patent, but once I get it, I may be valuing it more than what it's actually worth in some sense. And so I have to get maybe a larger licensing premium or something else in order to relinquish that right or to give up that exclusivity, right? So that there might be a little bit of that going on. I think maybe more often it's just simply not understanding what the right is and what exactly how to value it may be more salient than the endowment effect. But it's interesting to think about how that might be working in some situations. I mean, certainly if in the university setting, if there is this signaling value or other value, then just simply having this portfolio of patents and publications might tend to have the owner value it more. Maybe even the university might value it more than what somebody is willing to pay who doesn't have that particular.
Wouldn't risk ever been explained this as well?
Yeah, it could. Yeah, I mean, this is the issue that might arise. So what is your thought about this?
Simply that, well, there's a certain amount of investment that needs to be made for commercializing any patent that I actually have.
Right.
Well, I may have to market it, or I may have to actually set up my own initial beta version.
Yeah.
Investment in terms of resources, investment in terms of time. Some
Yeah.
investment is there.
Right.
I don't know how much return it's going to give me, or maybe I know how much return it's going to give me, but there's a risk reward factor involved. And if I'm a very risk averse person, and in a university setup, it's not very difficult to think about the patent holder being a risk averse individual.
Sure.
I simply don't want to incur that kind of an effort to commercialize it.
Yeah, maybe. I mean, that's interesting. And then why do you obtain it in the first place? There's some other motivation.
Well, there's a signaling value can explain the first side of it, or maybe there's no cost, or maybe there's a government grant going on, or maybe university grant is going on. I have resources. I put in the resources, get the patent. Now my effort is involved.
Yeah.
I don't have to do that.
Yeah, so I mean, that's interesting that the Kitsch model assumes that under the prospect theory, once you have the property right, you'll go out and take the risk of commercialization, that much of having the property right mitigates that risk, right? That because then you can sue if somebody steps on the right, whatnot. But I think what maybe the Kitsch model is ignoring, I think as you're pointing out, that there might be other risk factors in commercialization and forming a business, doing the entrepreneurship, that the property right doesn't resolve. And I'll actually go a little bit further. Maybe the property right actually makes it worse, right? Because then once you say you have the patent, somebody might challenge your patent. It might invite somebody to sue you for infringement, and so forth and so on, right? Okay, so I think that there might be an element of that. I mean, certainly in the university setting, one of the concerns that many university administrators have is how do you get the technology out there to the public? I mean, there have been lots of success stories. So at least at the University of Wisconsin, there's several that have been touted. For example, warfarin was a pharmaceutical that deals with heart medication that was developed within the university. There's the whole vitamin D. There are a lot of agricultural type patents that you see not just with Wisconsin, but in many of the land grant or agricultural universities in the United States, that the technologies were developed and they were able to go out. And part of the reason why they were able to go out is that the university had some sort of infrastructure that permitted it. There may have been the university industry collaboration that might also have allowed for some of that risk sharing to happen. You're not seeing the same thing necessarily in the ICT sectors or in the biotech sectors. Maybe for a combination of things, including the question of who should bear the risk of moving forward in those particular areas. That the risk is particularly acute and harder to define in biotech and ICT than it was, for example, in developing agricultural techniques.
How does this patent exactly work? See, if a private company works with a university like state, and finally the patent goes to whom?
Yeah, good question. So this is another aspect. This might get also to some of the aspect of the market failure and some of the legal reform that I'm going to talk about. I'm going to remove my jacket just briefly. So that's largely, basically the patent goes to whoever is the inventor, And so if there are multiple inventors, then they own it jointly. And so that can create some sort of an interesting problem, right? When you have multiple owners of a property right, then the exercise of that property right becomes more complex, especially when you have one set of inventors that might be in one organization and one set of inventors that are another. So some of the issues regarding joint ownership may be legally part of the problem that arises with this. The way in which many of these situations are organized is to reassign the property right through contract. And so I'll talk a little bit about that. This is where the contract issue, as I'm going to talk about, comes into play. And so typically that can vary, and there's been lots of litigation about what that contract might say. But typically the university wants to take a stake, and the company may be willing to give the university that stake in exchange for getting some sort of a license, or maybe an exclusive license or a more favorable license that might be granted outside. So that's one way to structure it. Sometimes the university, depending upon how the original, so for example, the university researcher may actually work for the company as an independent contractor. And in that situation, the private company would say, okay, we get the rights, you just assign all the rights to us. And then there have been some litigation, especially with the University of Wisconsin, regarding this. There's a big case against Intel a couple of years ago that the university won, where Intel was claiming, no, we got the rights in the patent based upon our contract with your researcher, and the university said, no, we have the patent rights. And when that was eventually resolved, and it was a matter of contract law. And so that's one of the things, is a good example of one of the issues that I want to talk about regarding contracts. Okay, so what I've laid out so far is just the point that just simply having the property right doesn't necessarily lead to commercialization or transfer or dissemination, whatever the case might be. You have to look at these ways in which some failures arise in the licensing market or in the tech transfer market, however you want to describe it. And I've described several of them. They may be just simply, badly defined property rights or ill-defined or misunderstood property rights. There may be some psychological effect going on, maybe through something like the endowment effect. Or there might be just simply a question of organizational incentives, that there might be an incentive to get the patent, but there may not be any incentive to do anything with it, after that particular level. And so how do you actually align those incentives?
Yes, I understand the endowment effect part of it, but that should really be a short-term phenomenon. So therefore, if endowment is explaining anything, you only know that the patents are going to be withheld from commercialization only in the short term.
Yeah.
Because very soon or later, one will get a realization that it's not worth as much as I think it is.
Yeah.
Therefore, we all know that we start with the Africa and slowly settle down for
It might be. I don't know if you see that over time. Maybe part of the problem is that the life cycle for the endowment effect is longer than the life cycle of the technology, or however you look at it, right? So if you think about ICT or biotech, where the technology field is changing every maybe 5 years, let's say. But I guess you're saying that the psychological effect should decay a lot faster than the technology, right? Yeah, I don't know the answer to that.
In other words, if one were to look at the patent grant status and the time in which it is commercialized, one could measure that.
Yeah.
And if one could show that in the university setting it is larger than in a private setting, then that's a test, right? Essentially, the endowment effects are letting university to believe it's slightly larger.
Yeah, that's interesting. Yeah.
And the endowment effect might be very confusing in a university setting where we talk about the university as one thing, but the bureaucrat, the administrator might have a different view of it. The lawyers might have a different view of it, and so there might be this communication problem or coordination problem as to who exactly decides about the commercialization and what is their incentive structure as well as their psychological mix. I don't know the answer to that, but it's an interesting question. I guess if you look at examples where technology commercialization has been successful, and so what might be worth, I wanted to talk a little bit about that. How have they been successful? So I gave the example of warfarin. Usually they have been discrete problems or projects. So the situation that arose with warfarin, as I understand it, this is maybe the stuff of mythology, but warfarin was developed maybe in the 30s or 40s, and there's some story about a farmer in Wisconsin. His livestock was dying because of some virus, some other type of condition, and he brought the dead livestock to the campus to say, can somebody solve this problem? What's going on here? And then the researchers focused on that discrete problem, came up with a solution, and then they figured out a way to disseminate that solution. And so this is maybe something very different than the prospect theory. This is more of a directed project. I mean, so if you think about large-scale example of this, I mean, we think about the Manhattan Project with the development of the atomic bomb. There's just a focus on a particular problem. The problem in general has some delineated endpoint or solution, and then the question is, how do you coordinate all of these parties to come up with those solutions? And so you can find examples of that in other areas. So for example, there's a whole area about patent pools. And so you have patent pools in the 19th century involving the sewing machine, very famous sort of sewing machine patent pool that arose. And the basic idea with the sewing machine is that there are various components to the technology. And different companies had patents on different aspects of the broader technology. And again, the broader problem that brought the companies together was how do you make the most desirable, or at least the technologically most desirable sewing machine, given the components that we have. Well, we will cross-license and create some sort of a patent pool. And the interesting example of patent pools is that there was litigation. So maybe the litigation risk can never be mitigated. Some of the litigation risks maybe can be mitigated if you look at some of the history more recently. For example, with the smartphone patent pools and some of the standard essential patent issues, to using competition law or other contracting regulations to try to mitigate that problem. And I'll talk a little bit about that in a minute. But the sewing machine situation, you have the coordination that arose and you had the products, but there was litigation. And that litigation may have been a result of, even back in the 19th century, some of the fuzziness or uncertainty as to the boundaries of the property right, some of the questions about who actually had patent ownership, as to go back to your question a few minutes ago, as well as some of the contractual issues as to on what terms were they cross-licensing. And this is the 19th century. This is almost 200 years ago when you're looking at these types of cases. And the same issues you see later on. So you have the automobile type patent pools, airplane patent pools. You think about Curtis Wright, the Wright brothers and Curtis coming together to try to pool the technology. Again, there's one unified kind of goal in mind, and so you can bring the forces together to then solve that problem, but that doesn't necessarily resolve other types of problems. And so even nowadays, you think about a successful patent pool, successful in the sense of technology dissemination and commercialization. So patent pools regarding memory drives, patent pools regarding USB, various types of hardware related patent pools involving the DVD writer, and patent pools involving the smartphone. The smartphone war is going on now. Again, there's some sense of what the problem is, and then coordination, but then there might be some boundary questions that get arise. The one thing that's interesting about current patent pools, and this is where I think we need to think a little bit about the engineering and the science, that we have some sense of what the solution is, but maybe we don't have a real good sense, for example, with smartphones. What is the outer edge of that boundary? What exactly is the perfect smartphone, right? And we don't know that. We may not also know the same thing with various biotechnological innovations or biomedical innovations. How long can human life be expanded, right? What kind of therapies can we... So there is still that uncertainty in terms of the endpoint. So even if you do have some notion that we need to cooperate, there might be this uncertainty that still remains that can make some of these patent pools unsuccessful. So my point in this discussion, in this phase of my talk, is that clearly there might be some problems in commercialization, but there are also success stories. And we need to keep in mind those success stories, the ways in which they are successful, the ways they're not, as illustrating ways in which that we solve these particular problems. Okay? So are there any questions or just... So let's, yeah, please, yeah.
Other side of commercialization, which is, for example, the university system putting in more effort towards open source standards.
Yeah, good.
In other words, I discovered something, I take the idealistic position that it's in the mankind,
Yeah,
Therefore, I disseminate it in a non-commercial.
right.
Do you see any evidence of that actually?
You see, no, people actually do that. I mean, there's no question that that happens. You see that, for example, with Tesla, right? With the electric car. You see that with some example that comes up quite a bit with the polio vaccine, right? Jonas Salk was with the University of Pittsburgh, and so there was some question about whether that's open source. And that's also a source of controversy. There's some people who look at the history with the polio vaccine and say that it's not so much that Jonas Salk did not obtain the patent, it's that he was not successful in obtaining the patent. That he could have, but the lawyers or the university, there was some organizational failure in getting it. So I think your broader question, as I understand it, this gets to the next phase of my talk, is I've given you successful stories. Are there other lessons? Are there other strategies that we can think about by which we can have commercialization of technology other than patent pools? And so let me just finish this thought as one example. One thought might be, if there is an endowment effect, for example, or if there is just some licensing failure because of matching, then one way to resolve that problem is to maybe make it open source. Just simply tell the world this technology is available and you can come and get it at whatever terms there might be. Right? So that's the way I would characterize open source as a strategy to deal with the dissemination issue. The question then is it successful? Does it actually lead to the dissemination of technology? At some level it might. There's some question, for example, with the electric car as to whether it's facilitating. It's still too early to tell the development of new technologies. If you look at, for example, the Human Genome Project, you had the Craig Venter approach that was more proprietary, and then you had the National Institute of Health approach that was more open. And it's not completely clear as far as finally mapping the human genome. There's a strong argument that being open may have led to it, led to the result of the mapping, so the invention occurring. It's not as clear as to whether the follow-on is happening. And part of the problem with the follow-on type inventions is that there has been a lot of uncertainty as to what extent, for example, can you patent the human genome sequence? To what extent can you patent the therapeutic and diagnostic tests that arise from that situation? So even though something is open source, there's still residual property rights issues that might have to be resolved. So that by itself can't resolve the problem. I think it might be useful. Again, it's a comparative institutional question in my mind. Compared to what? It's helpful in terms of letting the public know that this is available, but it may not fully resolve these types of issues. Is that?
Yeah. See, when you talk about success stories,
Yeah.
are they mostly related to the technology which are made open for public good, or what I want to know is when you make them for commercialization, do you see less success there, or the other side when you make open you see more success?
Okay, and I think the question is, it sometimes depends upon the technology and the nature of the work. So I think for vaccines are a good example. I think for vaccines, having a more open approach for the public benefit and so forth, whatever it might be, may be more beneficial for dissemination, right? So there are lots of different variations on that. One of it, of course, is that there is an external benefit from having the vaccination. And so if you simply, and this can work in lots of different ways, but if you just simply price the vaccine and say, okay, only the people who are willing to pay for it then can get the vaccine, then it may be very hard to reach that critical threshold where enough people are immunized. See, there is sort of a free rider problem there that arises, right? Because I won't get vaccinated because I know somebody else is willing to pay the $500 or $50, whatever it might mean, to get the vaccine. So why should I pay? I can get some benefit for that. But the public benefit only accrues when enough people. So even just having one person, and so let's say the patent owner says, I'll sell this vaccine for $1 million, so only one person can get it. Clearly, there's no public benefit to that, or it might be very minimal. And so that might not be the best strategy. In fact, at this point, it may not be a credible strategy for the patent owner to say, I'm going to charge a very high price, because you'll still have an outbreak of the disease, and there'll still be a demand, right, for that vaccine. So it's a question of reaching that critical value, and the open source or the openness of the vaccine might be very helpful for that. There might be other residual aspects of having the openness of the vaccine that is very interesting. As you know, there is this very odd movement, I think it may even be in India, this anti-vaccination, that the concern that vaccines themselves may cause a disease. So there's a lot of discussion about children being immunized for measles or smallpox that may cause autism. I don't think the scientific evidence shows that, but there is this. There is some evidence that there are some bad vaccines, so those are just badly manufactured and administered. That's a separate question. And so can openness make the knowledge more, so in other words, if it's viewed as proprietary, as viewed as something that's secret, it may be harder to overcome those barriers. Now, realistically, those barriers may have just completely different ideological and psychological dimensions to them, but this is where open science is really part of what I'm talking about. Just having the information out there that's available can be beneficial in that particular context, right? So that's one aspect. The interesting question is, are there cases where commercialization has led to failure? I tend to be pro-commercialization. I'm not, and I think in certain situations, the success stories of commercialization, I think, have been positive. I mean, I can't think of very good examples right off, but let me suggest two things. One of the things that really spearheaded the aerospace industry was, of course, World War II. And so you did have, aerospace, you did have demand or some market for airplanes, in the 20s and the 10s and 20s and in the 30s, but it was still a fledgling industry. And once you had World War II and you had the government or defense need, basically the government broke the patent, maybe not expressly, but they negotiated these uses of the aerospace technology to develop it for war purposes. That certainly had some sort of spillover in terms of developing the private passenger commercial industry after World War II. So I think the feedback mechanism is fairly complicated there. But if it was just simply meant to be commercial, I think some of the defense purposes, again, we can criticize that, but they were obviously beneficial defense purposes, may have been more difficult to realize. Right? So that might be one example where commercialization would work against the public good. If you look at diagnostic and therapeutic biotechnology, so there's lots of litigation about this and lots of dispute about this. For example, the company you might be familiar with is 23andMe. So you give them a sample of your DNA and they can give you a gene map of what diseases. And so there's been a lot of discussion about that. And there is some patenting, and there's some cases about whether there can be patents on these types of genetic and diagnostics and genetic therapies. I can talk about that separately. So that debate is still going on. And again, the usual line that there should be patenting to encourage it, or the other view that there shouldn't be patenting because there may be nothing novel really in these types of things. But there is some question about whether the commercialization is helping, whether they commercialize. And I think there the question isn't whether commercialization or not. The question is, are they commercializing too quickly, right, before they really understand the technology? And that's a separate issue, but I think it's related to this question about commercialization. So it is possible to commercialize too quickly, and that's something that you need to be concerned about. Any other? Okay. So I'm going to go through the last phase of the talk. I think maybe I'll finish a little bit after 5 o'clock or so. Lots of good discussion. You've got the idea behind my thesis and so forth. Let's talk about some of these alternative solutions. So I've talked about patent pooling, as one example, and the way you have the coordination problems and how that can be resolved. Underlying this question, I'll just say at the outset, is not so much purely a matter of property rights, but also a question of contract. And so this is one of the areas in the scholarly literature as well as in the strategic literature that has not been fully developed. What exactly is the relationship between property rights and contracting more broadly and specifically in this particular area? And so there has been a tendency to view the property rights as something that should be superior to contract rights, even in much of the litigation to say that the property rights should trump the contract rights. And this can come up in lots of different ways. There's much litigation in the 1960s and 1970s, and this comes up in many countries, but in the US, as to when a patent owner engages in certain types of contract terms, whether that can be viewed, those contract terms can be viewed as illegal or as violating the extension of the patent, right, or effectively extending the life of the patent in an illegal way. Some of this interaction between patent and contract law can occur through antitrust law. And I'll get to that in a minute. But there are some cases where it's not antitrust law. The court just simply said the property rights should trump the contract rights. Yeah, I'm about to, but sure, go ahead. Yeah. Yeah. I'll give you the example. This is a very interesting example. That original case was in 1964. Brulati versus Tice was the case. And then this issue comes up again actually 2 years ago in the US Supreme Court, where the US Supreme Court is asked to review this precedent. So let me talk about the precedent first. That'll illustrate the example, and then this continuing dispute about this question about property and contract. So in Brulati, you had a patent owner for a machine that allows for the picking of hops, barley essentially, that was licensed to farmers. And this license occurred in the state of Washington in northwest United States. And one of the terms of the contract, of the license, was that the farmers had to keep paying the licensing fee even when the patent expired. So the patent would last for 14 years, but the term of the license said that the farmers have to pay for 20 years. And so the idea is that they get the benefit of that technology even after the patent expires, and therefore they need to pay for that longer term. So once the patent expired, the farmers, the licensees, basically said, well, why are we still paying for the rights to get access to the patent once the patent has expired? That seems to be a contradiction, or at least something that's legally in tension. So this went all the way to the United States Supreme Court in 1964, and the United States Supreme Court agreed with the farmers and basically said that if the contract term for payment is going longer than the life of the patent, then those additional years of payment are illegal. The farmers don't have to pay that. So I won't go, but we can go a little bit into the economics and the business of this, but why this decision was so controversial, right? I mean, so the idea behind payment and the idea behind use and access to the technology are two distinct things. So there's no reason to think that you might have to pay for the technology even after the patent has expired. There are lots of rationales. One of it may be a credit type arrangement. It might be an arrangement where there might be other types of intellectual property. So for example, know-how that the farmers are paying for beyond the term. So this is a very controversial decision, but it's been the law since 1964. The European Union in its technology directive basically did not accept this rule. They only accepted it in a very narrow situation where there was some example of dominance by the patent owner and some evidence that the patent owner was trying to exploit the patent right, but very hard to show, right, those types of situations. But generally the European Union rejected the rule to basically say that just simply having the longer contract term does not violate it's not in contradiction with the property right. Okay, so just to finish this thought, this issue went up to the US Supreme Court in 2015. Again, almost 50 years later, more than 50 years later, the court was asked to review this precedent, and the court basically upheld the precedent. But it was a very divided court. And so there were 4 justices, 4 out of the 9 who were dissenting, that basically said this rule makes no sense. Economics, business people have said this rule makes no sense. It's very easy to avoid this rule, so people know that this rule doesn't make much sense. And so why do we still recognize it as precedent? But the Supreme Court basically said 5-4 that, well, this has been precedent for 50 years, we can't change it. So there's some very interesting debates and issues that arise there. But this is kind of illustrating the point about the relationship between patent and contract. That we need to think about, maybe this answers your question about how the patent-contract interface works. And so let me,
So I have a slightly different question.
Yeah, sure.
So what you're describing, the precedent here in the US, it's a blow on commercialization, right? Essentially, I mean, the incentives reduce.
Yeah, it doesn't help it. In fact, it's worse than a blow. I mean, a blow has lots of different meanings, but it certainly does, talk about the property right as separate from the contract right. And if you think about the contract right as what, is really maybe fueling the commercialization, it does seem to create this interesting, just conceptually dynamic where the property right is trumping this commercialization aspect. Maybe that's what you're, yeah. It's actually even stronger than that, and I'll give you some examples. This is the next part of my discussion here. It actually creates the incentive for strategic behavior. Because in the case of the farmers, the view was that you had this Dutch company, the Thies company, that had these patent rights and they're exploiting the farmers. Whether they were or not, that was the rhetoric. And this is certainly the rhetoric in the opinion. The opinion was written by Justice Douglas, who was a very populist judge, right? And so many of his things, he was big in antitrust, big in securities, so much into market regulation. This is sort of an example of that. Ironically, he's actually, extolling the patent, but in some ways trying to get at the patent owner, who's trying to control it. But if you look at subsequent cases that raise this issue, the situation is reversed. So for example, in the case that went to the US Supreme Court in 2015, the patent owner was a small independent inventor. And the facts of this case are kind of funny. It's a Kimball versus Marvel case. And the inventor in that case had invented a toy. And so the toy was associated with the character Spider-Man. He had invented a toy that would allow somebody to wear something on their wrist and it would sling a web, much like Spider-Man would have it. And he had obtained a patent on this. And so Marvel is Marvel Comics, the big company that has all the comic books and the toys and so forth, and also the copyright in the Spider-Man character, licensed this technology. And so the interesting thing there was that there seems to be some evidence that Marvel was using the rule from the 1964 case strategically. Because they were saying, okay, let's enter into license agreement forever, and then once the patent expired, they said, oh, wait a minute, we have this rule, we don't have to pay anymore. And a previous case to this that didn't go to the US Supreme Court, but Judge Posner was the judge in this case, also involved a small inventor versus a large company. So the small inventor was an engineer, a sound engineer, acoustics engineer, and he had developed a sound stereo system. And it was licensed to the Dolby company. Dolby does the sound systems for theaters. And again, you had the large company, small inventor, same situation. Dolby enters into this license agreement that goes for a long period of time, and then suddenly, once the patent expires, oh, by the way, we don't have to pay you anymore. Right? So it's kind of very interesting, the strategic behavior. Certainly the small inventor often may not be well advised legally, may not be aware of the law fully in terms of the nuances. And so you get this, not only just simply a blow, and strategic behavior that also exacerbates the problem. Maybe, yeah. So this comes up. Yeah, this is what the antitrust issues. I can talk some more about all of this, but this is kind of illustrating this point. And so how do we find solutions? I mean, so there are lots of ways in which we think about this. The Brulati case may be one. The one about the farmers, the 64 case, may just be an outlier, because there are other cases where the courts have found more in favor of contract. So one of my favorite examples is a case where you had, again, an independent inventor. She had invented a new type of keychain. Very simple invention, mechanical invention. Basically, it has two parts to it. One was a ring where you put the keys, and the other one was like a cylindrical tube that you slide the two together and they lock. Very simple invention. And so she had licensed or got into a contractual arrangement with a manufacturer that they would make and market these types of things. But the terms of the contract were as follows. The terms of the contract were that she was going to pursue a patent. If she obtained the patent, the royalty rate would be 20%. But if she did not obtain the patent, the royalty rate would be 10%. And so as it turned out, she did not obtain the patent. The technology was too simple to get a patent on. So the company was keeping paying, but at the 10% rate. But then the company realized, under this other case, if you have a patent but it expires and you don't have to pay. So here we've got a case where there's no patent. Why are we paying? Right? So there's the logic that they followed. There the Supreme Court ruled in favor of the patent owner, right? Basically saying that the contract rights and the property rights are separate. And the parties negotiated this, that if the patent was granted a higher rate, but they're getting the right, the company, the manufacturing company was getting the right to access the technology early, so there's nothing wrong with them having to pay for that. They're just simply having to pay less than what they would pay if they were licensing the patents. So this is a very interesting case because it's sort of the correct alignment of property rights, patents, and contracts in terms of allowing the patent owner to engage in certain types of contractual arrangements that facilitate commercialization. And so you have these kind of different legal rules that come into play. Let me just talk just to complete, because I could go on with other dimensions of this, because as you see, once you start looking at these issues, they get more complicated and complex. So one of the aspects that I mentioned was antitrust or competition law, and maybe I'll end on that particular note, how competition law plays a role in negotiating the relationship between property rights and contract. The basic idea, of course, behind competition law is that some firm might have obtained some sort of dominant position, or you might have a group of firms that are getting together and they're manipulating the market in some way. So they're operating in a way that would be exclusionary, that may be something that would shift the market in one direction, and maybe one that may have some redistributive consequences, but might also have some efficiency consequences. So that they might be acquiring more rents, but society actually might be worse off because of the kind of contractual arrangements they've entered into. And so this is where competition law comes into play. I don't have any direct answers to some of these questions, but this is meant to just illustrate and to give you a sense about this property contract dynamics. Think about something like standard essential patents. So standard essential patents are situations where, again, you have a patent pool, where you have a situation where companies are engaging in some sort of a cross-licensing of their underlying property rights. And the question is whether the access to that standard, that some sort of technology becomes so standardized that that access must be given under the terms of that contract. In other words, the property right owner loses the right to exclude or gets some limitations on the right to exclude. Now, I think that particular issue is complicated. I mean, there are strong arguments against that restriction. But what we have to understand with the standard essential patents is that it's a choice between property rights and contracts. And if the standard essential patent doctrine, if those types of rules are being set up in the correct way, consistent with competition law, then what we're understanding is that the contract rights that are created through the standard setting organizations might actually complement or facilitate the patent rights. But the hard issue is to make sure that those competition rules are correct, and this is the stuff of ongoing academic debate as well as practical debates. And so I'll just leave it at that as some examples about how the patent and property right contract law interface can arise. Other examples arise, for example, in the case of exhaustion, if people are familiar with the notion of exhaustion. So exhaustion is where somebody has, a patent owner or a copyright owner has sold something in the marketplace, then somebody buys that item. The question is, can they resell it? So there are lots of different examples of this. It comes up, for example, in pharmaceuticals. One of the famous examples that went to the United States Supreme Court was a student in Thailand. He was a graduate student. I think he was studying first at Cornell and then at UCLA. And in order to finance the graduate education, what he was doing was buying the textbooks in Thailand, which were sold very cheaply, and reselling them in the US, where the price of the textbooks were much larger. And so he was arguing that since the books were sold legally in Thailand, and he bought the books legally in Thailand, he should be able to resell them in the US under this principle of exhaustion. So I won't get into all the details behind this case, it's controversial, but the bottom line is the United States Supreme Court held in favor of the student, that there was this exhaustion principle that would apply in international trade. And so this, again, it has some very interesting property contract interfaces, because sometimes the books are sold. For example, the books, in this case, Wiley, the publisher, had sold the books in Thailand under the contractual restriction that they can only be sold in Thailand. And so effectively what the court was saying is that contractual restriction was trumped by the exhaustion principle. And there are many cases now. There's a very famous case involving Lexmark, where this issue between the intersection between property and contract is now going to be decided in a more clear situation. And so ongoing debate, but this is another example of where it's helpful to think about that property and contract is not so much an either or, but contract as actually lubricating or facilitating the exercise of property rights. So I've spoken for about an hour, but I'll be glad, and thank you for the questions, but I'll be glad to discuss some more. Yeah, okay, great. Yeah, thank you. Thank you for having me.